Yes, yes, metaphor, right, right. And Steve Sachs, I think, was your former
Yeah, yeah,
clerk. So
yeah.
he was so delighted to have you back. And I just saw another clerk of yours, Ann Joseph McConnell.
Oh, yeah. Where'd you see her?
At Berkeley.
Ah.
I think she's moving to Stanford.
Yes, yes. So I hear.
Yeah, so they're losing, I would say, one of their best
Yeah.
professors.
Paul, did you get any insights from the new head of the PTO?
Well, I've read all the speeches and I've had some conversations with him, and he says all the right things, but whether he can make the bureaucracy cooperate, I'm not so sure.
The composition of the panelists was rated to patent, not to Article 3.
What do you think of Randy's article?
No.
I think, I mean, we can probably handle our.
Basically talked about the fact that
I'm also happy to talk about intercollegiate broadcasting if you wanted to sort of
Oh,
talk about IP agencies more generally in an opinion that you wrote.
Yes, yes, I know.
I was talking a lot with Ann Joseph about it.
That produced a very interesting, didn't produce, it was part of the subject of an article by John Harrison. What is being done in cases of that sort.
Yes.
It was a very subtle point. I don't think any court has grappled with what he said.
And I can tell you that I think this is not speaking out of school. There's a professor at Minnesota, Kristen Hickman, who also has a little bit of a critique of their case. Her view is that it doesn't really remedy the problem to take away the protections, the job protections from the Primary Royalty Board judges. I haven't read the article, but she did tell me about it. I'm happy to forward it to you. I think
Sure,
it's public now,
sure,
if you like.
yeah.
But it sort of was beyond that.
But obviously all of those issues are very squarely front and center now.
Well, I guess so. I've never quite. I've been given a quite extensive biography of each of our speakers, and I'll try to summarize them very briefly in the order in which they're going to speak. Arti on my immediate left is co-director of the Duke Law Center on Innovation Policy and an expert on intellectual property. Certainly fits her for this panel. And let me see, it's been funded by NIH and the Kaufman Foundation, as well as the Woodrow Wilson Center, and many publications in very distinguished spots, and was administrator of the Office of External Affairs for the U.S. Patent and Trademark Office. Judge Michel, as probably all of you know, is most very distinguished member of the Federal Circuit, now retired, and has published numerous articles on patent law and advocacy. Let me see. Oops. Melissa Wasserman from University of Texas Law School, and I think it's the usual very distinguished array of publications and so forth, but has a BS in chemical engineering with high honors from Pennsylvania State University. Work on the thermodynamics of network forming liquids at low temperatures. So if we want to get into the weeds on that, we can be led there. And finally, out of Mossoff at the Antonin Scalia Law School, right here in the within the Beltway. Also an expert on patent law, but his writings on patent law and policy have appeared in lesser organs such as the New York Times, Forbes, Investors Business Daily, The Hill, Politico, etc. So I won't take any more of your time. We're going to go left to right from my perspective, right to left from yours, each speaker taking about 10 minutes, and then we probably have a little time for the panel to mix it up, and then have questions from the audience. Thank you.
Thanks so much, Judge Williams, and thanks to the Federalist Society for the invitation. It's really great to be here. It's the second time I've been here in 5 months talking about some of these issues, so I feel very much at home now in the Mayflower. Before we get to the various constitutional and rule of law questions with which we're going to grapple on this panel, I'm going to talk a little bit about the patent system more generally, and also more specifically about the constitutional, well, the policy reasons behind the creation of the Patent Trial and Appeals Board, which is the institution on which we're going to focus our constitutional and rule of law analysis. So I want to do a little bit of stage setting with respect to the policy reasons for why the so-called PTAB, as it's affectionately called, was set up as a consequence of the extended patent reform debate that started in 2002. I know that policy is not our focus here, but in order to understand why it exists, and it is a sort of a strange institution in lots of ways, I think it's important to understand the policy issues. And for what it's worth, because I was at the PTO during the time these proposals that led to the PTO were being debated, I've done a lot of thinking about the policy issues as well. So there was, at the time particularly, a real functional problem that the PTAB was intended to address. So I'll go to talk about that and then move on to the constitutional and rule of law issues. So what was the problem? Well, around 2000, something very interesting began to happen in the U.S. patent system. Prior to that time, for the past 25 years prior to that time, so 1975 to 2000 or so, the number of U.S. patents in force, that is the number of patents that could be asserted against potential defendants because they were being maintained, quote unquote, at the patent office, had hovered at about 1 to 1.2 million. After 2000, though, we began to see some substantial increases, and now, circa 2016, we are at about 2.78 million, so that's about a 278% increase. during this period, the number of district court judges who would hear these cases in Article 3 grew by precisely 12. So that's from 657 to 663, about 2%. So Congress, for whatever reason, did not want to spend money in that direction. At the same time, circa 2009, when I was thinking about these policy issues, the courts had decreed, they actually decreed at the Supreme Court level in 2011, that all of these 2 million plus patents were entitled to quite a strong presumption of validity in the courts. So in general, they could be and can be overturned only by a showing of so-called clear and convincing evidence. And that is a standard is quite deferential, if you think about it, to the PTO. So to the extent we're concerned about undue deference to the administrative state, that seems interesting. And as some of you probably know, to overturn a patent in a district court by clear and convincing evidence, particularly if one is going to a jury, can cost a lot of money. Now, that has changed a little bit since the PTAB was put in place, and that's where things get a little bit wonky with respect to the policy explanation, because after the PTAB was put in place, the Supreme Court threw us a curveball, and I think it's a terrible curveball that they threw us, but they did. It's a really wild curveball involving this kind of murky concept of patent eligibility. And I think most of us in the patent community think that those cases are really a problem, and we hope they get overturned by Congress. But the challenge now in the district courts is, on the one hand, if you don't have this patent eligibility kind of magic bullet, it takes a lot of money to overturn the patent. And if you do, and you're the patent, if the defendant does have it, and it's the plaintiff is the patent owner, well, it's an absolute mess of a doctrine. It's inconsistent, poorly applied, and I think almost no one would disagree with that. So that all of that means that courts really don't, in my view, even now test validity in any kind of particularly proper way. So we have juries who certainly wouldn't understand thermodynamics or monoclonal antibodies or semiconductors, often adjudicating validity, or we have this murky doctrine of patent eligibility. In the PTAB, fortunately, that for a variety of reasons, the murky doctrine of patent eligibility doesn't apply, and we certainly don't have juries. And so those are some pluses for the PTAB. And the other plus for the PTAB, it seems to me, is that its review is by the Court of Appeals for the Federal Circuit, is de novo on law. So to the extent, again, we're concerned about taking power away from Article 3, this is a very interesting sort of standard of judicial review. For those of you who don't do patent law might think, well, don't they get Chevron? At some level, doesn't the PTAB get Chevron? Well, not really. They have argued for Chevron in a few tiny procedural instances, but they don't really get Chevron. So again, I don't see this as really taking power away from the courts. If anything, if you think about it, it's giving the it's giving courts an ability not to have to apply this absolutely very onerous, clear and convincing evidence standard, even when they think the PTO got it wrong. Which I think, having been at the PTO, I can tell you that the PTO is not recognized for always getting it right. So, and even if you think the PTO denies too many applications, if you think it gets it wrong because it denies too many applications, the current system is set up so that you can argue that denial. But if a competitor thinks that an application has been wrongly granted, there's no way for a competitor, before the PTAB, there was no way for a competitor really to challenge that incorrect grant except by this expensive Article 3 procedure, and now through this very murky and I think inconsistent patent eligibility procedure, which I don't think anyone would endorse. So, so I do think there's a policy case to be made for the PTAB. It does have also, in addition to having being fast and relatively inexpensive, it does have expert judges. Judges have to be trained in a science and the law in order to serve on the PTAB. They have to have either a college or postgraduate education in a relevant science, not just a science, but a relevant science, so they get the cases that are patent cases that are in their area of scientific expertise, which is a really remarkable achievement if you think about it. That does not happen even at the Federal Circuit, as distinguished as it is. I don't think one can say that the Federal Circuit is particularly, a font of scientific knowledge in specific areas, whereas the 300 patent judges are all trained in specific branches of science. So I think this really rebalancing of power, for the most part, is not only good as a policy matter, but if you think about the ways in which it doesn't unduly detract from the Article 3 judiciary, I don't think there's any constitutionally problematic usurpation, at least as a functional matter. So to get to the question that I think we will talk about a little bit, the constitutional challenge that's been brought to the PTAB, I think from a functional perspective, that's probably not a concern. Now, most of you may not be functionalists in your orientation, so let me then move to a more formal constitutional perspective. I think from a formal constitutional perspective as well, and we can have a nice discussion about this because here it gets more interesting, but I think from a formal constitutional perspective, there's certainly a very strong argument to be made that this is not a separation of powers problem. We can talk about all of the different things that were said in the briefing and at the Supreme Court oral argument, but it seems to me that it's hard to argue that patents granted by the U.S. Patent Office at the rate of about 350,000 per year represent exactly the same thing as a property right granted in fee simple in land. And even Justice Thomas noticed in his Teva versus Sandoz opinion from 2015 that, quote, patents have no counterpart in the Lockean state of nature, unquote. So, one can, I think reasonable minds can differ, but I think that to say that they're just like a piece of land in fee simple is perhaps a little bit of a stretch. In addition, it's noteworthy that the PTO has had procedures for revoking patents in place since 1981. Now, the reason these procedures weren't used very much was that they were cumbersome and poorly designed, but they were actually not that different from the PTAB as a matter of constitutional principle, formality, in other words. Now to the rule of law issue. So the rule of law issue is a real problem for the PTAB, not constitutional rule of law in my view, but a rule of law more generally. There are things that the PTAB needs to do. I only have a couple of minutes, maybe 1 minute left. And I have many articles talking about all the ways in which PTAB procedures could be improved, rendered more consistent, rendered a better alternative to Article 3 courts, which is what they were set up to be, with, of course, robust appellate review. We can talk about all of those things. I think that there's much that could be improved about the PTAB, and I think that the current director and the past director, for that matter, have been trying to do a lot of that, and the PTAB has become better, but it could be better still. I also think that there are probably other things that Congress could do to grant, for those few patents, say, held by pharmaceutical companies that do look more like property rights in fee simple, your patent on your killer blockbuster cancer drug. I have argued in print that there should be a specific, rigorous patent examination procedure for those kinds of ex-ante, for ex-ante examination of those kind of extremely valuable patents, but not really for all the 2.78 million patents currently in force. So that's my short spiel. I've got a lot more to say, but I will turn it over to our next distinguished panelist.
Good morning, everyone. I want to be clear that I am not opposed to the Patent Trial and Appeal Board or its review procedures under the American Invents Act. But I think Professor Rai makes a very forceful point about the procedures and the balance of rights and protections between the challenger and the patent owner, who of course are the opposing parties in front of the Patent Trial and Appeal Board. I'd like to focus on the arguments made and the understandings and expectations when these reviews were created, particularly the inter partes review, which is usually referred to as IPRs. because there's a huge gap between what was expected, what was assumed, and what actually happened. So, for example, expectation number one was that a very limited number of these petitions would be filed, and an even smaller number result in adjudications. What actually happened was it was 3 or 4 times the estimate made by the Patent Office itself, and I believe the number now is in the range of about 6,000 of these things have been filed, and a very large portion granted. As Professor Rice said, the seminal notion was that these reviews would be an alternative to expensive district court litigation. But what actually happened is they've just become the prelude, because the vast portion, over 80% of the cases involving IPRs have co-pending infringement suits that have been filed in the district court. So what normally happens is the patent owner identifies an apparent infringer, files an infringement case, then the accused infringer files in the patent office an IPR petition. In almost all of the cases, the district judge, understandable since they're so overburdened with unmanageable caseloads and are too few in number and many unfilled vacancies at any given time, the district judge usually grants a stay for the duration of the litigation in the patent office, including an appeal. The third idea was that it would be quite rigorous because it would be essentially limited to documents. The statute says patents or articles, printed publications. But what's actually happened is almost every IPR now involves dueling experts filing declarations, undergoing depositions, and then the Patent Trial and Appeal Board in many cases essentially chooses which of the dueling experts it finds more credible and more reliable. So again, a huge variance between what was expected and what actually happened. And oddly enough, although the proceeding is called a trial, there are no witnesses. So the adjudicators, the 3 judges on the panel, never see the experts, never get a chance themselves to ask questions of the experts. So that's a very odd sort of trial. Fourth, the statute contemplated that the director of the patent office or policy subordinates of her or him would have the mission and the ability to screen these cases, so there would be attention to the impact on the economy, the impact on the inventive ecosystem, and those would be reasons for denying a petition even if the threshold of proof was met. But what actually happened was the entire package of duties were delegated to the Patent Trial and Appeal Board, and the patent director and policy subordinates didn't do anything by way of screening any of these cases. It was also assumed, fifth, that there would be a rather free practice of allowing amendments. What actually happened was amendments are virtually never allowed, and there was the thought that not only would there be amendments, but there would be something in the nature of an examination where there was an amendment. But of course, no amendments are allowed, and nothing resembling an examination actually occurs. Sixth, the retention from the prior procedures of re-examination of the standard of review of a mere preponderance was justified on the basis of this amendment and quasi-examination process. So the IPR standard, which is, as was pointed out, considerably lower than the standard in an Article III court, was sold based on a premise that turned out not to be true in practice. And finally, seventh, there was an expectation that repeat challenges against the same patent, particularly by the same challenger, would not be allowed, but what's actually happened is they're frequently allowed. Now, it's my premise that validity of a patent, particularly for obviousness, the most rigorous screen in the Patent Act, is a legal issue, and therefore ought to be decided under standards and procedures and protections that one would find in an Article III court. what's actually happened, though, is completely different. So the standard of proof, the independence of Article III judges. I mean, Article III judges are mid-career distinguished professionals from the legal world who are appointed by the president after a rigorous selection process and vetted by the Senate, have to be confirmed by the Senate on behalf of the people, and they're usually in their 40s or 50s. The Patent Trial and Appeal Board judges are mostly associates who decided they wanted to leave law firms and become employees of the patent office. They have no tenure. They can be removed pretty much at any time for any reason, as I understand it. So huge disparity in the nature of the decision makers and their level of experience. Now, a comment has been made that they're trained in science, which is true. I think it's not accurate that they sit on cases in their own scientific discipline. For one thing, there are many disciplines not covered by anybody on the board. And for another, the workload is such that they have to assign people who are available. So often people are sitting on these cases who don't have any technical experience. And even those who do, their degree of experience is far less than the examiner who granted the patent in the first place. There are 273 judges, so-called judges, really employees. There are 8,000 plus examiners in very specialized areas who do nothing day in and day out, year in and year out, but examine in a very, very narrow technology. So what you have is people on the board overruling examiners, even though they have far less technical experience in the precise area involved. Now, former Director Kapos has said repeatedly in public and written that when the procedures were put in place, it was understood and assumed that it was just a first cut, that they would need to be revised in light of experience. But what actually happened is they didn't get revised in any material way in all the years since then. So one of the results of this, in my opinion, but also the opinion of the Chamber of Commerce study that comes out each year, is that the U.S. patent system, compared to all the other advanced country patent systems, which was always first year after year, fell to 10th in 2016 and to 12th in 2017, tied respectively with Hungary and Italy, not known as hotbeds of innovation and technological leadership. What our ranking will be in 2018, I can't say, but I have to assume it will continue to go down because nothing much has been done about the Patent Trial and Appeal Board procedures, which I think, but I can't prove, skew the results and explain the very high invalidation rate, which runs between 60 and 85%, depending on whether you talk about all the claims invalidated or only some of the claims invalidated. So in addition to the ranking, there have been other alarming statistics. The formation of startups in the United States has fallen 40% to a 40-year low. In some recent years, more startups died than were born. That's the first time that's ever happened in this country. There's been, according to some economic studies, a 60% drop in patent values overall on average, and a 60% drop in early stage R&D investment. So a lot of warning signs, and the attribution is to the combination of the eligibility cases from the Supreme Court and the high invalidation rate in the patent office. Essentially what's happened is the investment community, the financial community have lost faith in the patent system because they see patents as too unreliable to create enough incentive to make the investments needed. So my hope is that the new patent office director, Andrei Yank, who has only been in office a couple months, will finally make the changes in these procedures and burdens to equate them with what goes on in Article III courts. And if he does that, I predict that the invalidation rate will go down substantially and the whole process will have more fairness and more credibility and hopefully restore the confidence of the financial community. So that's the big picture.
So I want to start by thanking the Federalist Society for inviting me to speak on this very distinguished panel. And what I want to spend my time with my comments is just situating PTAB more in the modern administrative state, right? That is to the extent we have a number of legal challenges that are being brought against the structure of PTAB. It would be helpful to understand which aspects are really unique versus which ones are sort of commonplace in agency adjudication. And so my comments are going to draw heavily from an article that is co-authored with Chris Walker that's forthcoming in California Law Review. So just to begin, PTAB, we don't think PTAB is actually APA-governed formal adjudication, right? They're not overseen or presided over by ALJs. Instead, as Chief Judge Michel has noted, we have administrative patent judges. And I think the second reason why it's easily not APA-governed formal adjudication is there's no direct appeal to the agency head. So when PTAB makes its final decision, you can ask for a rehearing, but you can't get it appealed to the agency head. You go directly to the federal circuit. Now, that being said, it has a lot of hallmarks of formal adjudication, right? There are hearings, there's a ban on ex parte communications, the parties receive notice, et cetera. But if PTAB isn't APA-governed formal adjudication, what is it? Well, administrative law scholars refer to, I think the best category for it is type B adjudication. So these are adjudications that require an evidentiary hearing from the statute, like what the Patent Act does, and they can be very formal or even more formal than APA-governed formal adjudication, but they're not technically governed by the formal procedures that are outlined in the APA. And I think the most prevalent type of type B adjudication we see in the modern administrative state is immigration appeals that are overheard by non-ALJs. So one question is how well does PTAB stack up to these other type B adjudications that we see in the administrative state? And I think on some dimensions, relatively well. So there's an ACUS report that came out last year on type B adjudication that Michael Asimo, among others, wrote that tried to identify what should be the best practices of type B agency adjudication. And they identified 20 of them. PTAB met 16 of those, and if you compare them to other type B adjudicators, it was in the sort of top 1/3 of meeting best practices. Now, there is room, obviously, for improvement, but it seems to, at least stacking up to other type B adjudications, do relatively well. So the next, I think, question is then, what sort of features or what sort of aspects are unique about PTAB in comparison to other type B adjudications? And we identify 5, and I'll just sort of briefly touch on those, and then I want to talk a little bit more about how I think the lack of agency head review complicates things for PTAB. So one, and some of these have already been brought up, is that PTAB adjudication that receives the most attention is that you can think of it as disputes between private parties. So there are agency adjudications like that, disputes between private parties rather than the government and a private party, but they're not the majority, I think, of agency adjudications. The second, I think, somewhat unusual feature has also been touched on by both Professor Rai and Chief Judge Michel, right, is that you can have these parallel proceedings that occur in the agency and in federal district court, right? And that's also a feature. You see it some other places, for example, on the trademark side of things as well, but it's not, you don't find it that frequently. The third way we note is that you actually do have to pay a substantial filing fee for PTAB, about $15,000 to do PTAB adjudication. And this is because the Patent Office is user fee funded, and they're simply just trying to recoup their costs associated with this proceeding, but that is also somewhat unusual. And the fourth way is that most private enforcement agency adjudications, in comparison, PTAB has a much greater number of cases, right? Since its inception in 2012, the PTAB has over 7,000 petitions, and why this falls really short of something like the Social Security Administration that adjudicates many more, right? It is relatively unusual, especially because PTAB's sort of the final decision maker in the agency, that you don't have any additional review over that. And Arti Rai has touched base on, I think, on some of the features in PTAB that raise challenges because of its caseload management. consistency in adjudication, etc. And so the final way I think that PTAB differs from other agency adjudications is this lack of agency head review. So if you look in the modern administrative state, the paradigmatic agency adjudication, you can appeal it to the agency head or some sort of commission or some high-ranking body of additional officials. And why do we find that as the sort of paradigmatic structure in the administrative state? The thought process, right, is that you want the agency head to have control over the regulatory scheme, right, that she oversees, right, sort of policy control. And the other reason why we typically have agency head review is because it helps to bring consistency to the adjudicatory outcomes. And this has been something that people have complained about with PTAB, right, is they have close to 400 APJs. They're usually in 3-member panels, but you see some inconsistent results occurring, which obviously is frustrating to the applicants. And so if the director has no agency head review, how does she or he influence the outcomes of PTAB? Well, the primary way is that the Patent Act actually grants the director influence by enabling the director to designate members on the board. And so this quote-unquote, people have referred to this as panel stacking, has been a controversial practice. So what typically would happen is if a 3-member board comes out a way that the director disagrees with, they will ask for an expanded panel. It will be granted in a rehearing, and then the director or some high-ranking official will select APJs to be on that panel with the hopes that they are going to come out the way that the director would want. And so it does look like the director has the statutory authority. The Patent Act seems to give the director statutory authority to do this, but we argue in our article that this raises some constitutional due process concerns, especially in light of a Sixth Circuit case called Utica. And in Utica, what happened was you had the U.S. Department of Agriculture that brought a complaint with a meat inspection services from Utica Packing before an ALJ who decided against Utica. It got appealed to the sort of intermediate appellate board in the USDA where a judicial officer affirmed, got appealed to the Sixth Circuit. They disagreed, kicked it back to the judicial officer, right, who reluctantly dismissed the case. The Secretary of Agriculture was very upset, violently disagreed with this decision, pulled the judicial officer, replaced it with a new judicial officer, right, who granted reconsideration, and that judicial officer changed their decision. And the Sixth Circuit said that the Secretary's replacement of this judicial officer constituted a due process violation. The court refused to accept the argument that the Secretary of Agriculture, having delegated to the judicial officer the original authority to resolve certain matters, could reappropriate that power at will if they disagreed with the judicial officer's conclusion. And so you can make parallels, I think, between the director's designation procedures and Utica, right? Similar to the Secretary of Agriculture. In Utica, the director, in effect, removes the original panel before the end of the proceeding if she designates an expanded panel that will arrive at a different conclusion. So what I sort of think about is, are there other ways that the director could have control over PTAB adjudicatory outcomes that may not raise due process concerns? Well, first, of course, Congress could always give the director some sort of review, but that would require congressional action. But I do think that the PTO could do a couple things right now that would help them, right? I think the agency could rely, and it would probably be better for them if they relied more on rulemaking to announce some of their new principles governing sort of PTAB procedure, rather than trying to do it through PTAB adjudication itself. And the second thing I think they could do was rely more heavily on designating PTAB opinions as precedential. Right, because precedential decisions are binding on subsequent PTAB decisions, so this would cut down on some of the inconsistency. And I think one of the issues there is there's something like 1,500 written decisions from PTAB, and there's been like 13 that have been designated as precedential, which seems alarmingly low, right, given the fact that you have all these new novel legal questions coming out of the AIA. And I think one of the issues there is they have a very cumbersome process about designating opinions precedential. It requires over half the APJs now, which are close to 400, I guess, and the director to agree. So I think there are things they can think about by sort of shifting that decision to be more unilaterally with the director that may help them utilize this precedential status more frequently.
Thank you.
Thank you, and it's a pleasure to be batting cleanup. And and I'm going to go to kind of some more foundational issues, given that this is the Federalist Society, and they care about some of the more kind of fundamental questions about our constitutional structure and the foundations of a civil society. So I'm going to start with somewhat of a kind of obvious statement, I think, for anyone living in the 21st century, is that there's been a radical expansion in Article 2 in the executive branch from the 20th century up through today, which is really interesting because the founding fathers, of course, were much more concerned about Article 1, Congress, right? They refer to as the swirling vortex that will draw into it all of its all interests and all rights and all powers, and yet what Congress has been doing for the last 120 years or so has been kicking that all the interests and rights to the executive, and so of course this raises really fundamental questions about separation of powers, about due process, and about the protection of substantive rights of our citizens, of life, liberty, and property. And so the basic question that I think has been raised by the Congress's creation of the PTAB in 2011 with the legislation that's been talked about by our panelists, the American Vents Act, is there any real limit on the delegation by Congress of powers to the administrative state? And is there any limits on the exercise of executive discretion that impacts the substantive rights of citizens, and or in more kind of traditional language that Philip Hamburger likes to remind us of, right? Is there any limit on the exercise of prerogative in the rearrangement and limitation of people's rights? Now, whatever one might think of where is the dividing line between the various branches of government and their respective powers and checks on each other, and what therefore might be the limits on the administrative state, I think that we can look at the PTAB as simply a bridge too far, as an exemplar of regulatory overreach, that regardless of what the Supreme Court has said about the ability of Congress to delegate, the killing off of the non-delegation doctrine and whatnot, I mean that the creation of the PTAB just went too far. And I think this is exemplified by a lot of the policy issues that were highlighted by Judge Michel, and talked about a little bit both by Professors Wasserman and Rye, that it raises extensive numbers of constitutional questions and concerns. Fundamental questions of due process, which Professor Wasserman just talked about with respect to panel stacking, where there literally is, after the original 3-panel APJ, administrative patent judges, to which Chief Judge Roberts said during the oral argument, I think we use judge in a rather different sense of that term than you are using it to refer to the PTAB. That a 3-panel APJ will hand down a decision, and the chief judge of the PTAB will disagree with this, and it's more than just hope. They will add 2 more APJs to it, because this happened in an actual case. They added 2 more APJs. They came out with the same decision, and they said, no, you got it wrong again. So they added 2 more judges to the panels with now a 7-panel judge, and then they got the right decision, which was the opposite of the first decision, and then it was upheld. The Chief Judge Rusky is now going around telling people, oh, this is no longer happening. I brought an end to this process. But actually it is. It is continuing to happen. There's a case, Erickson, that's coming out of the PTAB, where it was another 7-judge APJ panel. And also they stacked a panel on the ownership of patents by the Mohawk Indian tribe. And that goes also to the issue of, yes, these are supposed to be technical experts, and also they're deciding fundamental questions such as tribal sovereign immunity, and people are wondering if this is appropriate or not. It raises real problems and concerns about separation of powers. Professor Rye said, yes, you'll have extensive substantive review by the courts, but as with all administrative agencies, the courts have said, well, we're going to defer to the PTAB on many issues, and in fact, this is one of the concerns that's been raised that underscores the policy points, the economic points that were raised by Judge Michel, that the courts essentially have held that a decision by the PTAB effectively as a de facto matter trumps a decision by a court. So a Article 3 court will say a patent is valid, and the PTAB will say a patent is invalid, and now you have a conflict, and the courts have held the PTAB wins. The administrative state wins over an Article 3 adjudication of someone's property rights. This cannot be what we intended to have in our constitutional order. And yes, I love Justice Thomas's reference that a patent is not like a fee simple in the state of nature. It's a great piece of rhetoric because Justice Thomas knows more than anyone that there is no such thing as a fee simple in the state of nature. A fee simple itself is a civil right that only comes into existence once you enter into civil society. Exclusive possession of land does not exist in the state of nature. And so real estate, the foundational fee simple that we think of as property, is a civil right. It's not a natural right. It's a civil right that is rooted in natural rights, rooted in rights of use and disposition and creation. And in fact, real estate, just like patents and inventions, are issued initially as patent grants, because a patent is just the initial legal acknowledgement in recognition that this is a legal property right. And so for all of you, if you do a title search in your homes, you'll find that they go back, here in Virginia, they may go back 300 or 400 years, but they go back to an original patent grant. So the Homestead Acts were started as patent grants, conditional patent grants, in fact, just like you have with patents that are conditioned on them being novel and non-obvious and useful and things of that sort. So, in fact, I've talked about this in my scholarship, that patents historically, legally, have been secured in the United States as civil rights, securing property rights that are justified by the same policy justifications that judges applied to other types of property rights that they viewed in the context of classic common law rights, and even going back to natural rights. And so this is ultimately the point, what are patents? Are these, in fact, private property rights, right? This is one of the kind of the foundational issues that I think we can't escape. The Supreme Court, yes, the Supreme Court can punt on this. The Supreme Court can do whatever it wants, right? Because why is the Supreme Court, right? They're the last. No one gets to check on them. So, but hopefully they won't if they're going to hand down a coherent decision in oil states as to what is the constitutional status of the PTAB. And, of course, with the court system, as any lawyer knows and anyone who goes to law school knows, right, you can always find court cases and court decisions that say one thing, and you can always find court cases and court decisions that say the exact opposite, right? So you have to look at kind of the weight of the legal authority. This is one of the reasons why I read every single patent decision that is recorded in the Federal Cases Reporters in the 19th century. There's about 1,400 of them. Why? Because that's what you get to do as a law professor when you don't have billable hours. And what I found is that the weight of authority was the treatment and security under the law of patents as, in fact, private property rights. Both doctrinally, conceptually, and normatively, courts repeatedly recognized and secured patents as being analogous to title in real estate. Now, what we mean by that is title, meaning the rights, not the subject matter, because of course all the subject matter of all property rights is different, and as we all learn in law school in our first year property courses, right, a fee simple refers to the rights in land, not the land itself. The patent secures a right, an exclusive right in an invention. It doesn't secure the invention itself. And so when a patent is issued by the patent office in the same way that a county recording office will issue a title in property or in land, that is a vested property right. It has been recognized as a vested property right. Yes, it was conditional on the terms of it issuing, just like you have conditioned precedents imposed upon fee simples through estates that you learned in trust and estates, and maybe you last saw when you took the bar exam. But the foundational point is once it's issued, then what happens is that the patent system, like every other particular legal doctrine, whether you're talking about whether you're talking about property rights in land, whether you're talking about rights in chattels or other types of rights, it becomes nested within long-standing constitutional doctrines and basic fundamental procedural and substantive rights that apply when you're talking about the protection of vested property rights. And that means adjudication and security by Article III courts, not by the administrative state, and particularly not by a completely unbounded administrative agency that is running riot, literally, with respect to the procedural and substantive rights of patent owners. So, thank you.
Thank you. So, we have half an hour for questions from the floor. Often when I moderate these things, I exercise my privilege to ask the first question, but recognizing that I'm the most ignorant person in the room, I will forego that and invite questions.
How does the right of a FOIA to somebody who has put in an application for a patent, and then you wind up with 3 or 4 people looking at that patent, as an agency, does the person have a right to do a FOIA to find out what the conversation between the other patent people were? Does that make sense?
Do you want to?
So
You mean the patent examination, the initial
Correct.
patent application examination? So the record of the patent examination, that anything that's not a trade secret in that record does ultimately become public for most patents after 18 months. So you begin to see that record after 18 months. That's part of our obligation through as a consequence of our signing on to the TRIPS agreement. And so for the most part, anyone who wants to seek international protection, that record does become public after 18 months. If there are trade secrets that are not related to the patent itself, then those maybe could be redacted, but there's a database called PAIR that gives you all that information.
PAIR, P-A-I-R?
P-A-I-R, yeah.
And I want to add one thing to that. So one controversy that's come out, or people have been concerned about, is that on these PTAB panels, right, they've been concerned that there's 3 APJs assigned to the panel, that they're having conversations with other individuals in the agency and making a determination. And under administrative law, that's perfectly acceptable, right? That it's not the same as Article 3 or federal, the judiciary, right, where we may think that would be an inappropriate type of ex parte communications, right? But for an agency, you can generally, the panelists could talk to other people in the agency, even for APA-governed formal adjudication. There's a ban on talking about disputed facts, but outside of that, typically, they're allowed.
I thought the question had to do with whether you could find out what the communications were among different judges on the original panel and others. And I think the answer is no, that if you seek a Freedom of Information Act request with the Patent Office, they will not reveal what those conversations and communications may have been.
Which shows you that they want their they want their cake and eat it too, right? They want to be treated like Article 3 judges for purposes of deliberation and things of that sort, and have the types of long-standing protections that judges receive. For instance, you can't FOIA their deliberations between themselves, but yet they want to also have the benefits of being an administrative agency and administrative judges and being able to go outside and the bounds of the normal rules of operating procedures for judges and to have ex parte communication.
But let me, I want to push back on that in several ways.
Okay.
So in the administrative state, right, if you're under APA governed formal adjudication, ex parte communication, that there's a ban on that, right? And the PTAB has adopted an ex parte ban. But that ban in administrative state is from interested parties outside of the agency speaking to the judges, right, or the ALJs or the APJs or whatever the name of the decision maker is, right? It is not what we sort of think of more generally in federal courts, right, a ban on them speaking to anybody, right? And so there's fundamental differences between agency adjudication and the federal judiciary. And I think part of the concern, right, and this is part of why it's great for patent attorneys, et cetera, to learn to think more about the administrative state, is that we just haven't had a lot of administrative law thinking in the patent side, right? And so there are aspects that we're trying to hold PTAB to exactly what we see in the federal judiciary, where, there's a difference, right? There's agency adjudication and adjudication in the courts.
I think the judge kind of understood the question, because the concern is basically once you get into a court system, I understand it, but once you're in and I have done patents, and I would like to know what the conversation was behind the scenes, and there are emails between these 3 or 4 people.
Yes.
And can we get those emails?
Well, you can FOIA for them, but they're going to be able to exempt them under agency deliberation.
I'm not aware that Article 3 judges reveal their internal deliberations on panels.
I haven't noticed it.
Yeah. I have never heard of the idea that Article 3 judges would reveal.
But we are isolated, as
Yeah.
Professor
Yeah.
Wasserman
But
was
these
pointing out.
are employees of the patent office that are making decisions and doing the work, and you're saying that basically the patent office is exempt from FOIA.
It's not exempt from FOIA. No, not at all.
No.
No. These particular deliberations, I think, probably would not be turned over.
No, they're not.
If you tried to FOIA, but I think that's true for all administrative
Yes,
adjudications.
that's what we're trying to say.
There's nothing special about.
And there's nothing sort of, within the administrative state, it envisions the decision makers speaking to other people in the agency when they're making decisions on law or policy.
But like one of my mentors and college professors, Philip Hannigan, would say, that actually is a problem with the administrative state.
Right.
Well,
I don't view that.
So-
There's an implied assumption in the
Sure.
this is normal for the administrative state. Well, yes, but then is that still proper?
Right,
That
and
begs
so,
the question.
so the question, if one wants to attack the APA full blown, that's a separate question.
Yes.
Right.
And
Yes.
one could do that, but
Right.
this is not unusual for APA governed adjudication.
But
Or
suppose,
even
suppose the
APA
four of
governed.
us are on a panel in a case that this lady has brought or is involved in front of the PTAB. And suppose that the four of us on the panel get a memo from the director of the patent office saying, you're to decide this case in favor of the patent owner. And that memo would be protected, and the participant in the proceeding would never be able to get that, would not even know it happened. And to me, that's very troubling, whether it's normal in some administrative agency context or not. It's very troubling on that hypothetical set of facts. I'm not saying that's happened. I don't know whether it's happened or not. But if it did happen, it seems to me it should be on the record, and the participants in the proceeding should have a chance to respond to that incursion by the director. But as far as I can tell, they wouldn't be told before the decision, and they would never be able to find out later if there was such a intervention by the director of the patent office.
So this is a strange, and this is just a historical footnote. It's a strange consequence of the way Congress amended the statute in 1927 without really thinking about administrative law, I think, at all. And this was pre-APA, obviously. They amended the statute. It used to be that one would appeal BPA. The BPAI was the predecessor to the PTAB, the Board of Patent Appeals and Interferences. It did somewhat different things, but you could appeal their decisions to the PTO director under that statute. Congress amended that statute in 1927 to say, no, you do this rehearing instead, which is a very unorthodox way of doing things, but it seemed that Congress was concerned about workload on the part of the director. But you have to understand that the ordinary administrative process involves de novo review by the political appointee.
Right.
That's ordinary bread and butter administrative law. And in fact, if it wasn't there, that might be unconstitutional in and of itself, because these are supposed to be part of the executive branch, and those folks who are devotees of executive power believe that to have unaccountable judges within the executive branch might be a problem.
Yeah.
As a litigator for whom some of my billable hours are before the patent office, I think I'm required to be in favor of PTAB proceeding. But with that said, it strikes me that the entire IPR process and the significant expansion of patent invalidations under IPRs is something you see in a lot of cases, which is a recognition of a problem, in this case, a vast expansion in the number of patents granted and the subject matter of patents granted. And then instead of addressing the problem at the root, which is the grant of the patents themselves,
Right.
You tack on another administrative process
Right.
or agency in order to deal with it. And I was wondering if the panel could comment on that.
Yeah, I think that's a great question. I personally think, so examiners on average spend 19 hours reviewing an application. This is reading the application, doing a prior art search, writing the report, reading the response, right, from the applicant, maybe an interview. And that just doesn't seem to me necessarily enough time to do as thorough as a job as they may need. Now, the bigger question there, of course, is the concern, what people say about spending more time and effort up front, is that so few patents actually are economically feasible, right? Should we just try to do it at the back end when they come out and have some additional process to review? I, though, above the vein, that we should be probably putting some more money up front on patent examination to improve the quality. I have some empirical research where I've sort of looked at this trade-off, and it's found that the savings we could save on patent litigation costs, we may more than make up if we just put a little bit more money up front on examination. But it's a great question. It's sort of an ex ante, ex post question, where now we have PTAB, which is sort of an additional ex post consideration, right? And when we're thinking about what's the most ideal structure, it's difficult to know how much we should put on each one. Except there seems to be an agreement that patent litigation on its own is not necessarily functioning well enough to take out all the invalid patents.
One might think that the protection, both for fairness and rigorous results, would be the appeal to the Federal Circuit. But the affirmance rate in these IPR cases is well over 90%. So I deduce from that the Federal Circuit is not able to meaningfully review the work of most of these decisions. On some procedural matters, they've done some remands, but on the actual merits of valid or not valid, they affirm at the rate of 90%, and it's easy to see why that is, because the decision always turns on obviousness. Obviousness is a legal issue ultimately, but it's a factual issue as to the predicates. So if the predicates are the subject of findings by the board, they can't be overturned by the Federal Circuit as long as there's substantial evidence, a very low bar supporting such findings, which there always is. And so it's not surprising that the review, I would say, is close to meaningless. So basically, the Patent Trial and Appeal Board has become more important and more decisive on the rights of people than the court that supposedly is reviewing it. That seems completely upside down to me.
And then I'd like to just to address real quickly, the concern about patent quality and whether there are bad patents issuing or not. We are now entering in the realm of what sometimes economists call soft empiricism, because we don't have a baseline as to how, are more bad patents allegedly issuing now than 10 years ago or 20 or 100? No. We don't know. And in fact, this concern about, whether the patent office is issuing too many, invalid patents or not, is making too many mistakes. You find extensive complaints about the exact same thing going back to the 1860s and the 1870s in the exact same frame, the exact same way. They're now issuing thousands more patents than they were issuing 10 years ago, and they're overwhelmed and they're not doing examination, and we need to address this problem. And there's a really great article called Dubious Patent Reform. It's published in the Boston College Law Review about 6 years ago that details this historical complaint about the patent system and how actually this is driven ultimately up to the PTAB. And I'd be remiss if I didn't also mention the Regulatory Transparency Project has a paper on this, on the PTAB, as an example of doing exactly what you said, of regulatory overreach by layering more regulatory review on top of both kind of a questionable empirical foundation of whether it was needed or not, in addition to kind of justify, turning an administrative agency to review itself more and creating more administrative processes, and just, in the words of the Declaration of Independence, eating out the substance of innovators by sending swarms of officers upon them, right?
So let me just talk a little bit about the empirics. So there was a study by the National Academy of Sciences, which is hardly a radical organization, and it put out, I think, a very good review of the state of the empirical evidence circa 2004 on this question. And the state of the evidence in that uniform report with only one dissenter was suggestive of a decrease in quality. And I think that it would be hard to say that you get a 270% increase in patent grant rates when you don't have a 270% increase in R&D spending. And there's something very strange about such a huge increase in such a short period of time with no other indicator that we've become massively more innovative as a nation or as a world. And so I think there are reasons that one could be concerned about patent quality. Now, your question is a really good one, as Melissa pointed out, that should we try to address it more ex ante? And I hadn't, in prior work, well before I became, a policy person at the PTO, thought about that a lot, not as well empirically as Melissa has. But one of the challenges is simply that it would cost so much, as Melissa indicated, to get a rigorous review of all those patents as they're coming in. We also have this view in the United States, which may well be a good view, that much better to have a false positive. In other words, have a bad patent go through and clean it up later than have a false negative. So, we do have this view that much better to let 10 bad patents go through than let one innocent patent to be denied. and the consequence of that is, and that's not true in Europe, for example. Europe does a much more exhaustive examination at the front end, which means
lower grant rate.
They have a much lower grant rate.
Applications.
Yeah, and we all think Europe is not as innovative, or perhaps many of us do. We don't want to look to Europe for our model, so we decided, we sort of looked to Europe for the model for the post-grant, but it was really more kind of coming up with it on our own.
I think it's very revealing that the invalidation rate at the Patent Trial and Appeal Board is 2 to 3 times higher than in the district courts, and 2 to 3 times higher than when the Patent Office star examiners in the Central Reexamination Unit review validity. So to me, that's very suspicious that the board has twice the invalidation rate of the reexamination unit or the district courts. That just can't be right. It can't be reliable results.
So I want to say one thing about that statistic. I think, it's very difficult just to compare the invalidation rate in a court versus PTAB, because there are, as I'm sure Chief Judge Michel would say, there's lots of procedural differences between PTAB and the board that could be driving that higher invalidation rate, right? For example, right, the board uses a broader claim construction. The board has a lower burden you need to meet to invalidate. The board, they don't even initiate a PTAB proceeding unless there is the director or the chief judge who's making a decision determines there's a likelihood that one of these claims is going to be invalid. So there's some pre-screening that's going on there as well, that may be giving rise to these differences. So I just want to be clear. We may disagree on those procedural sort of screens and aspects that are going on in PTAB, and that may be driving the differences. But I don't think that, and I don't think you were implying this, that the differences suggest, for example, that the APJs are biased against patents or something along those lines, right? We need to think more about the procedural aspects that we have in PTAB and whether those are truly the ones that we want.
Yeah, I agree with that. I think it's the procedures that are driving the high invalidation rates, not some kind of personal bias of the employees. But the procedures are so lax compared to procedures used in courts that it's not surprising that they result in wider invalidation. And so the procedure should be changed.
So I agree that some of the procedures should certainly be changed. Like, I'm not a fan of this broader claim construction. I don't know why they decided to do it, because it's inconsistent with, if it's supposed to be a substitute for the courts, they should use the same claim construction as the courts on patents. So I think some of the procedures need to be changed, but it's also worth noting that the invalidation rate has gone down, and that's invalidation once you've already decided to institute. It used to be up in the 80% range, and now it's gone down to 60-some%. And you only institute about half the patents that are petitioned anyway. So one can play all sorts of funny games as a lawyer with numbers, and one should be very careful about lawyers wielding statistics as a consequence.
Notwithstanding Professor Ray's reference to Europe not necessarily having a lot for us to glean for our own practices, are any of you aware of either patent laws or practices in other parts of the world that you think would help us if we considered applying them here to increase investment in innovation?
So I actually, I was being derogatory with respect to Europe just because that's a crowd pleaser. I actually think that, the more exhaustive investment up front in Europe is not, I'm not sure I endorse it, but I think we should look at it. It's considered so politically incorrect, if you will, to refer to the European model, though, at least in the circles I travel in, because the idea is that, well, they're not particularly innovative in Europe, and so why would we want to have this very high bar for getting a patent through the office? But I do think that it's worth looking at. One particular feature of other systems that I think is really worth looking at, Europe has it and Japan certainly has it in spades, is why does every patent have to be examined right away?
Right.
There's something called deferred examination that we tried to push when I was at the patent office. Not everyone wants their patent examined right away. A lot of entities just want to wait to see if their patent is going to be worthwhile, patent application is going to be worthwhile commercially before they go through the whole process. We don't have a system for that in the United States in any formal way, at least. And it seems to me that would be something that we could. It wouldn't even be that politically incorrect to adopt it. And we almost did, but there was a lot of pushback for interesting reasons that we can get into if you want.
Yeah, and one thing that I definitely think needs to be changed with the U.S. patent system that I've written about is the fee structure of the agency. So historically, if you look at the agency, it gets about 80% of its fees through three types of fees that patent applicants pay: an examination fee, a fee you pay when the patent gets issued, and a fee you pay called renewal fees to keep your issued patent enforceable. But if you look at the funding of the agency, it costs 3 times the amount someone pays to review an application, to do the examination, than someone pays, right? Which means the agency is heavily dependent upon issuing patents to get that issue fee and that renewal fee. And I've done some empirical work on this, and what we found is when the agency is really facing like financial strain, we see empirical evidence that they begin to sort of grant some types of patents that they earn the most money for. And so this has been something that I've been very concerned about, and just thinking about restructuring the fees so they get more fees up front, and they're not so dependent on issuance and renewal. And that's something that the European Patent Office has done. The European Patent Office does not get to keep all of their renewal fees. They actually give half of them back to all the national sort of patent offices, and they have more upfront examination fees, so that they have a structure that's shifted towards more cost recovery, which I think also has this additional benefit of that the agency is just more financially healthy, right? They are not as dependent upon the type of applications that come in with respect to their grant rate and the economy, which affects what the renewal rates are.
The cynics suggest that the 273 adjudicators on the Patent Trial and Appeal Board may have a personal interest in a high invalidation rate, because in the beginning there were fewer than 90 people on that board. Now there are more than 270. If the invalidation rate were to plummet, obviously the filings would plummet, and the need for those 273 people might well disappear. So the cynics say there's a perverse incentive among the members of the board to keep it as attractive as possible to people who want to challenge patents in order to retain that workforce.
And if we just have a couple of minutes, I mean, I don't know. I take a kind of a more historical and broader perspective on it, and I think that one can think of patent systems generally by dividing them between kind of a public regulatory model approach and a private law model and a private right approach. And I mean, there's on the margins there's some creepage between this distinction, but this is a general distinction as to how countries think about rights and rights that they're securing to people, and this is particularly true in the context of patents. And the United States historically has taken a private law approach to patent rights generally. So they issued vested patents as vested property rights. If there was disputes, they were handled between private individuals in Article III courts, and they were protected and secured in the marketplace. They could be transferred and secured in the market. They could be commercialized. You could use as collateral. You could actually bequeath them in wills. These are things that if you view these as public economic regulatory grants, you can't do. In fact, that was the English approach. They said these are property rights, but only in a legal sense, purely legal sense, because really these are just economic regulatory grants by the Crown, so they can't be transferred to other people in the marketplace. You can't bequeath them in a will. You can't, and so it impeded the source of patents as a source of commercial innovation in and of itself, which they became in the United States in the 19th century, which a lot of economic historians like Zarina Khan and Steve Haber and others have talked about. And I think that a lot of the problems we're seeing today in the patent system is that we've shifted away from that. I mean, in fact, the American Invents Act was driven largely by harmonization with other countries. So we shifted away from a first to invent to a first to file. We shift the adoption of the PTAB, the creation of the PTAB out of the pre-existing types of re-examination systems that they had was very much, the appeals. I was on the Hill talking about this as Professor I was at the time, and even Judge Michel, I think you were there at the time as well, right? They were saying we want to create something like Germany has, and which actually does have a fairly functioning post-grant review system, and so they created kind of a hybrid type model, which and has failed. So I think we should actually not necessarily look elsewhere. I mean, we had a really good functioning patent system, and you have to be careful of letting perfection become the enemy of the good. We had a good patent system, and if you want to create a platonic ideal of a standard we can't meet, you're going to constantly be tinkering with it, and what you end up killing is patents as stable and effective property rights, because that's what you need if people are going to commercialize with them. No one's going to give you a loan on a house if your title in your house is uncertain. And and if there's an agency that can cancel your title in your house at any moment, right? At any point in time, someone could file. Then you're good luck getting a loan. And what you're hearing from venture capitalists now, and startups and small individual entrants, is that that's now the problem created by the PTAB for them with respect to their property rights and their innovation.
Just one note. I mean, there's a bit of a causal problem here, because the Supreme Court cases on Section 101, that's what I hear about all the time. They happened soon after the PTAB was created. No one expected that. That was sort of like in Monty Python. No one expected the Spanish Inquisition. It was kind of like that. And he was like, what? We thought we had fixed the problem. There are no more bad patents now because... And then the Supreme Court came along and said, oh, no. So anyway, that's I think that's part of the issue as well. That
it's complicated,
It's the Supreme Court has heard this rhetoric about patent trolls, now for the last 10 years, and it decided it had an idea.
Okay, can I follow up that with one question for all the panelists, and that is, very succinctly, a predicted outcome in oil states?
No change.
I don't think the Supreme Court's going to hold the PTAB as unconstitutional. I think that you probably have maybe a 7-2 or 6-3 decision with the Chief and Justice Gorsuch and maybe Justice Thomas joining, if they view this purely as an administrative law separation of powers issue.
Yeah, I would say probably maybe 5-4, maybe 6-3, but there'll be a dissent which will, I think, illuminate a lot of issues well for future challenges, which there will be.
Yeah, and I also think it will be upheld. I don't think it's going to be unconstitutional.
And by the way, that's a statement against interest, because I actually
will you join me in thanking our panel?
Well, thank you. And thank you, Judge Williams, for great panel. Thank you.
I learned, if anyone else learned, I did. It's a great panel.